those victims who were utterly helpless and who relied on her, their mother, to protect them and meet their needs. As noted earlier, Ms. Bilecki did not commit these offenses under the influence of any substance or as the result of any known mental health diagnosis. It is difficult to conceive of more serious conduct constituting the offense of murder in the second degree than a mother's actions in deliberately taking the lives of a 4-month-old infant and a 13-month-old child in incidents 2 years apart. Ms. Bilecki has no prior criminal history. However, her likelihood of rehabilitation appears quite poor, since these offenses were not the product of substance abuse or any known specific mental health defect. There is no treatment the court can order to address the underlying causes of her conduct. As quoted earlier, the Court of Appeals has held that incidents of unexplained and unprovoked violence may indicate that an offender is seriously disturbed and unusually dangerous. That quote applies precisely to Ms. Bilecki. The 2 murders here were the epitome of unexplained and unprovoked violence against extremely vulnerable victims. In these circumstances, there is little, if any, hope for rehabilitation. Without any reason to believe that rehabilitation is likely, there is a strong need to confine Ms. Bilecki to prevent further harm to the public, and especially vulnerable children. When Ms. Bilecki is released in this case, she will be in late middle age, approaching senior citizen status. When she is released, there needs to be a significant amount of suspended time hanging over her head to deter her from engaging in any further criminal conduct. As to the circumstances of the offenses, the extent to which these murders harmed the victims cannot be overstated. She ended her children's lives, and she inflicted lasting, irreversible harm on the families. The sentence must address deterrence and is focused specifically with regard to the suspended time on deterring Ms. Bilecki when she is released. Her initial period of incarceration is for 45 years. The amount of suspended time hanging over her head should be for at least as long. The probation conditions are designed to protect vulnerable children who cannot protect themselves. A significant amount of suspended time hanging over her head is designed to deter her from violating the conditions. If she does violate them, she should understand that she will be risking incarceration, potentially for up to the rest of her life. The sentence must also reflect community condemnation and the reaffirmation of societal norms. Community condemnation for the murder of a child by a mother. And here, Ms. Bilecki murdered both of her children in 2 separate premeditated incidents. Finally, the court must consider restoration of the victim and the community. There is nothing the court can do or say that will restore or ameliorate the harm the victims and the families have suffered. Regardless of the sentence the court imposes, it will not bring these children back. The harm the defendant has inflicted is so serious that it cannot be undone. The only small way in which the sentence can further restoration is to include a restitution requirement for any counseling, funeral expenses, or other expenses the families may have incurred as a result of the offenses and may wish to seek through the state. After considering all of these factors, the court places the greatest weight on the seriousness of the offenses, the need for deterrence, and the fact that the unexplained and unprovoked violence underlying these crimes supports the conclusion that Ms. Bilecki is seriously disturbed and unusually dangerous. In these circumstances, the amount of suspended time must be significant enough to deter Ms. Bilecki from violating the conditions of her probation or endangering any vulnerable children in the future. If she serves 45 years and has only another 30 years of suspended time hanging over her head, she may feel that the bulk of her sentence is behind her. The suspended time imposed must be significant enough to deter Ms. Bilecki from committing any future crimes. In other words, not that the bulk of her sentence is behind her, but that an even greater sentence potentially awaits if she engages in future offenses. For these reasons, the court will impose sentence as follows. On count 2, CTN 004, murder in the second degree, the sentence will be 65 years with 40 years suspended, 25 years to serve. On count 5, CTN 006, murder in the second degree, the sentence will be 65 years with 45 years suspended, 20 years to serve. Both the active time to serve and the suspended time will be consecutive. The composite sentence is 130 years with 85 years suspended, 45 years to serve. Ms. Bilecki will receive credit for time already served in this case. On both counts, she will also be placed on probation for a period of 10 years. Based on the date of arrest in the pre-sentence report, Ms. Bilecki may be eligible to apply for discretionary parole under Alaska Statute 33-16-090-B6A after she serves 40 years of her sentence on approximately August 30 of 2058. Under the version of Alaska Statute 33-20-010 applicable to Ms. Bilecki's offenses, she may be eligible for mandatory parole on approximately August 30th of 2048. The court has no control over the mandatory parole provisions enacted by the legislature. There are also mandatory surcharges that the court must impose. Those are a $100 police training surcharge and a $100 jail surcharge with an additional $100 suspended. Because this is a felony conviction, Ms. Bilecki will be required to submit a DNA sample upon request to the Department of Public Safety. We also need to get fingerprints for the judgment. I'll serve you. right, fingerprints have been taken for the record. Any bail not previously forfeited is exonerated. Ms. Bilecki, you do have the right to appeal any portions of the sentence that were not part of your agreement with the state. If you wish to file an appeal, it needs to be filed within 30 days of the date of the written judgment, and you should talk to your attorney about that. Anything else in this case today from the state?
I don't believe so. Thank you, Your Honor.
Mr. Reset. All right. Madam Clerk, anything else for the judge? All right.